from the College by the Lake, Coeur d'Alene, Idaho. Local, regional, national, and international guests discussing the issues and topics affecting the way you live are on Forum, the North Idaho College Public Forum, with your host and moderator, political scientist Tony Stewart.
I welcome you to today's program, and our topic today is the radical right and the United States Constitution. We've invited to the program a man who is an expert and certainly very informed on this issue, and a friend of mine and someone I have worked with in the past, and we're very pleased to have him with us. I welcome to the program Jim Vacher. Our guest is a member of the faculty at the law school at Gonzaga University. He holds a BA degree from Washington State University, received in 1969, and he got his Doctor of Jurisprudence from the University of Washington in 1972. He has been a member of the faculty in that law school since 1975, where he teaches criminal law, professional ethics, civil rights, and jurisprudence. He also is the former dean of the law school at Gonzaga University. Jim, it's a pleasure to have you here this week, and I can tell our viewers you'll be back next week to talk with us about another issue, and it's kind of you to take time to come to our campus and to discuss these important issues.
Well, thank you, Tony. I'm really glad to be here.
And as always, I'm pleased to have our regular panelists. First of all is Janelle Burke, who is an attorney in the state of Idaho, and next to her is Steve Schink, who is the Dean of College Relations and Development at North Idaho College, and I shall ask Janelle to commence today's questioning on the radical right and the U.S. Constitution.
Well, in addition to Tony's introduction, I must inform our viewers that you are a former teacher of mine and that I did take classes from you, and you were an excellent teacher, and in addition, I think you were one of those professors who always encouraged the critical thinking in your classroom. So it's just a pleasure to have you here today.
Thank you.
The question that I have for you to begin with is one that will set the stage, I think, for our discussion today, and that is, how do we define the radical right? Who are we talking about?
I think that's an excellent question, because I think we want to be very careful when we address these kinds of issues. There's a full spectrum of people who would be what I would call on the right side of politics. The groups that I'm interested in talking about are those that are on the very fringes, sometimes called constitutionalists, those who make some very strong claims of grounding in the law or the Constitution, which are clearly in error, that is what we believe, and that need to be isolated from the ordinary, what I would call mainstream of the right in our political spectrum. I'm not talking about groups of persons who are elected to Congress, who run for president, who are very, very conservative. I'm talking about people and address the question of those who tend to group themselves on the very margins of our political life.
Steve Schink.
Could you give us a few examples of how that marginalization exhibits itself in their beliefs or behaviors?
Yes. The interesting thing that we've noted about them, and by we I'm referring also to my co-author Mark DeForest, when we looked at this question on behalf of a paper I was presenting to the Northwest Coalition a year ago, we began to notice certain similarities in their claims about law. They make claims about the law as it relates to the Constitution, about the common law and what it means and its relationship to the law. They make claims about citizenship and who is not a citizen and classes of citizenship. They make some claims about the militia as organized under the Constitution, and they make some claims about the right to revolution. In each of those, they ground themselves in historical claims of historical accuracy or truthfulness. And what we decided to do was to carefully examine their beliefs and hold them to a test of truthfulness. Is what they say true? Does it correspond with what we know of our history, with the documents, with the intent of the drafters? And we found common error after common error. And so we look in those areas and make some judgments about the value of the discourse that they add to our political discussions.
One quick follow-up, if
Sure.
I may. Violence isn't always a characteristic of the radical right, is it?
No, in fact, the radical right, even the militant far right that we're talking about, is sometimes simply groups that propound particular ideas that I think are wrong, but don't necessarily engage in violent action. Sometimes violent action is an outgrowth of this behavior, but not always. And we hasten to argue and to recognize and to insist that people recognize that the First Amendment protects ideas, even ideas that are wrong, but that we think that the light of truth and cast upon them can reduce the power that those ideas have.
Thank you.
Jim, what we want to do today is, you've done a wonderful job of laying the outline for us. We want to do really two things. We want to take each of those areas that they have been advocating a position that they claim is grounded in the Constitution, and let you tell us, one, what their position is and why you believe it to be an error of interpretation of the Constitution. I'll start with the first one. Let's talk about common law, because it is one of the four areas that they spend lots of time on. What do they say common law is, and what rights does it give, and then the contrast with the Constitution?
Thank you. That is probably the fundamental claim that they make. These others are also important, but this one is very dynamic and very much at the center of their arguments. Basically what they say is that persons, certain classes of persons, which we'll talk about later, have natural rights primarily surrounding the right of control of property, personal and real property, which is grounded in what they identify as the common law. The common law, as we understand it, generally simply refers to that body of principles for deciding cases in the absence of statutes or an application of statutes to particular cases. And that's a far cry from their claim. Their claim is that the common law is a set of immutable principles that have been handed down essentially intact from centuries ago, and that controls all decision-making in the United States, that the common law is the preeminent body of law that controls everything and is composed of immutable principles, and the only people that have the right to decide what the common law is a jury. Now, in each of those claims, and there are about 5 or 6 that I mentioned in that brief introduction, is simply flawed. It doesn't relate in any fashion to what is well understood as the development of the common law over time. And certainly, for example, the claim that the common law somehow is the grounding of the Constitution and speaks louder than the Constitution to resolve issues is simply fatally flawed. The Constitution itself recognizes the existence of the common law in Article 3, but also contains a clause that's called the Supremacy Clause. It says the Constitution, in all cases in which there is a division of the House, in which there is debate, controls over any inferior law, including the common law.
Now, the Founding Fathers of the United States Constitution were much closer to the history of common law, and when they wrote the Constitution, as you indicated, they not only recognized common law, but they incorporated the Supremacy Clause. Am I not correct to interpret this to say that our Founding Fathers understood with the social contract, that is the Constitution, and we've added amendments, and then we have many statutes under the Constitution, that once you put it in writing, it is oftentimes incorporates many of the common law principles, but it also takes precedence over anything not written. Would you elaborate upon that?
Certainly that's true. It can become a very complex analysis, the interrelationship between the common law and statutory law, but there isn't any question that our principles of a written constitution and legislative supremacy in matters generally simply establishes that the authoritative way of reading the law is to put the Constitution in the preeminent position, statutes, to the extent that they are constitutional, the written law next in order, and in those interstices, in those places where they do not touch, then the common law can grow and fill in gaps. And certainly that happens all the time. It's very important, I think, to recognize that the common law is not a set of immutable principles that were inherited from Elizabethan times or some even preceding that, but rather a dynamic and flexible and growing body of law that changes over time with changed social conditions. And that's not what these militant far-right folk claim.
One more question on common law, and then I'll go to Janelle. The Constitution of the United States and our federal laws and our state constitutions and state laws, among other things that they do, not only they spell out clearly, oftentimes, or many times it's clear, what procedures are of how to administer law or how we elect officials to administer law and answer to us on the Constitution, but What seems of great concern with the radical right is that if they just arbitrarily pick a jury to apply common law, then the general citizenry would have no control over who they were or have any checks on them. Would that be a correct interpretation?
I think that's an exactly correct interpretation, aside from the fundamental error that jurors don't decide legal questions.
Right.
The fact that you can somehow impanel a jury extra-constitutionally, beyond the statutes, and give them authority to make decisions that affect people simply has no support in any history that I know of. It has never been the case, certainly is not the case now. And that's that error that I keep suggesting creeps in.
We have checks on elected officials. We would have no check on an arbitrarily selected group.
That's right. And one of the interesting problems that one sees in the development of these groups is they begin to splinter at times over questions like that, where one group asserts what we might call jurisdiction over its membership, the members resist and split off and form a new group. Well, the supremacy of law gets lost in that shuffle, and that again it demonstrates the problem with their analysis.
I'll let Janelle take us to another area.
The next area that we want to explore is citizenship with the radical right. Who do they believe has citizenship under the Constitution?
Well, there's another complex constellation there, but I want to simplify it because a lot of the documents that they write reflect this dichotomy. They generally claim that there are two kinds of citizens. One is what they call we the people citizens or sovereign citizens, and these are people that supposedly got their citizenship rights as the trade-off in what Tony described earlier in the compact, that they got rights from the exercise of granting or having the revolution and then having the Constitution. And that's one group. The next group is everybody else, and I'll describe who fits in each group in a moment. The everybody else are what are called 14th Amendment citizens, or citizens by statute, sometimes they refer to them. And basically that's everybody that isn't, and depending on which group we shape this a little bit differently, a white male. Now, you can see the connection between claims about racial imbalance and racial discrimination generated from there. We the people citizens are the true citizens of the country. Everybody else, including immigrants, non-white persons, Native American persons, women, are all something else. I have a real dramatic illustration, if I can take a minute to talk about that. If you follow that line of reasoning, I teach a basic political science class, and a couple of weeks ago we were talking about the franchise and voting. I had everybody in the class stand up, and I said, all right, now we're going to pretend that we are citizens of the United States in 1919. All the women may sit down now because you don't have the right to vote. And I went back all the way through the class. People of color can sit down because of the Civil War and so on. And when we ended up, the only people left to vote was one person who was a white male that owned property. And it is that kind of claim, which is completely specious about citizenship, that these groups make. That the white males are the only ones that have any political power, in effect.
When in fact the Constitution addresses the
Right.
question of citizenship.
Right. When we talk about error, and thank you for getting me back on track, I get a little interested in this subject. When we talk about citizenship, they completely misinterpret the purpose and meaning of the 14th Amendment, which granted citizenship to all persons residing in the country, in effect, whose exact purpose it was, and there's no doubt about this in the history of the 14th Amendment and the Civil War, 13th, 14th, 15th Amendment, Civil Rights Act, and so on, was to grant equal status for the former slaves. And that's what its purpose was. Well, we turn it completely upside down if we say it created a different kind of citizenship. In fact, what it did was open the class of national citizenship to all persons, gradually, but immediately the former slaves.
Steve Sheen.
Could we move now to a discussion of the views that the radical right holds regarding militia?
Yes, they make some, as many of us in this part of the world know, some very strong claims about the right to organize armed groups or groups that are committed to the defense of what they consider to be the fundamental rights of the country. And they make various claims that is granted to them as a part of the fundamental rights of being we the people citizens sometimes, or from the common law to enforce common law judgments and so on. And they make some interesting claims, somewhat inconsistently, that the Constitution grants them that kind of right, either the Second Amendment or more generally the Constitution's history. Well, in fact, that's just plain wrong. Our analysis suggests, and it's mainstream scholarship, we're not talking about anything unusual, suggests that the militia recognized both in the Second Amendment, which after all is an amendment to the Constitution's body 4 years, 5 years after it was adopted, militia there is the militia that's talked about in the body of the Constitution. And in the body of the Constitution, it is very clear that the Congress, the national government, has the right to control the conditions under which the militia operates, and in fact has done so consistently, most recently in the 20th century by recognition of National Guards, state militias, as the militia for purposes of the Constitution. And I might add something else we discovered during the course of our analysis, that several states, including the state of Washington, have specific constitutional provisions in their own constitutions, Arizona being the other one that occurs to me immediately, that prohibit the organization of people in armed militias. So the documents in our history speaks very clearly that privately organized groups that arm themselves and claim the right to defend the country simply have no standing under our constitutional system.
And in some places are specifically prohibited by state statute.
And in some places specifically prohibited by state constitutions. In many other states, very significant restrictions or limitations in state statutes as well, yes.
Thank you.
Jim, let me take this one step further also. As we have seen some problems in modern times of what we call hate crimes, a majority of states in this country have passed a significant number of statutes based on their state constitution, and one can also say the U.S. Constitution, to combat those crimes. And what you've brought to my attention is that one of those statutes addresses what is called, in Idaho it's called Domestic Terrorist Control Act. In some states it's called the Anti-Paramilitary Training Act. So when individuals go out on their own as a group and train, if the intent is to, as a group, to engage in violence, then there's criminal statutes covering that. So that would have a relationship to the U.S. Constitution, state constitution, about the proper definition of a militia or National Guard that's under the jurisdiction of the governor and the president.
Absolutely. One of the ways to look at the difference is if it were truly a militia recognized and legitimated by the law, that's one thing. Otherwise, they're terrorists. And we have a constant history in our country, sometimes overzealous, and I won't defend some episodes in our history that police thought in the guise of police inaction, but we've consistently said, even in the modern era, that terrorist activity is not protected by the Constitution. And if one is going to arm oneself and engage in criminal behavior, that can be classified as terrorism, and often is.
And if it went to the point that the terrorists actually attacked the government, then it could come under the category of treason, which is also defined in the Constitution.
Oh, there certainly is that possibility. It's rare that we've had any prosecutions for treason because there are lots of easier crimes to prove than treason.
It's very difficult to prove that one other
Yes.
definition. Let's move to the fourth area that your article with your colleague addressed concerning this issue of the radical right in the Constitution, that is the issue of revolution. Would you first tell us their concept or interpretation of, going back in history, what they think revolution is or what they could do?
Right. Well, revolution in that way of looking things is gathering together with fellow citizens whose rights are being abused and overthrowing the government. I mean, it's a fairly simple claim, has a pedigree in history. After all, our country started with an act of revolution against England. Their claim is that, in effect, and this is where, as I discussed earlier, this relationship between them and the Constitution gets so fuzzy, that somehow they have inherited the right to engage in revolution and to make the judgment when a revolution is necessary. Now, one of the things they've done is conflate the Declaration of Independence and the Constitution. It's quite clear from the history of the Constitution that it does not incorporate the claim in the Declaration of Independence of a right to revolution. I don't address, and I think we have to be very careful to not address moral claims about the right to revolution or ethical claims about the right to revolution, about which there is surprising amount of agreement among all kinds of ecclesiastical as well as secular authorities and philosophers. Here we're talking about making a claim, a legal claim, an enforceable claim to be protected from prosecution, for example, for terrorism, because I'm engaged in the right to revolt. Well, the fact and the simple, plain truth is that the Constitution explicitly recognizes the right of the government of the United States to suppress revolt. And so to claim that somehow one, through the Constitution, has the right of revolution is simply, completely false.
So you're indicating that in the Constitution itself, the actual language is that the government is authorized to suppress insurrection. Those words are actually in the Constitution.
And it has, in fact, been done on more than one occasion, although not recently. It happened in Shays' Rebellion in the 18th century, and it happened in the 19th century when some folks tried to overthrow the constituted government of the state of Rhode Island. Simply is not there, and it's well recognized that it is not. And in fact, in what some on the left would consider to be a somewhat shady constitutional doctrine and analysis in the 1950s, the Smith Act was upheld, which prohibits terrorist insurrections. It was applied to the Communist Party, and some people think problematically, but nonetheless the court clearly in the Dennis case in the late 1950s established the right of the United States government not to suppress ideas, but to suppress those who would violently overthrow the government.
And one more question before I go back to the panel. Let's go back to the Declaration of Independence. And even though you indicated and articulated clearly the difference between the Constitution and the Declaration on this issue, but even could one not make some argument there that Thomas Jefferson, who's credited with this language, that even he warned against impulsive revolutions when he said that government long established should not be changed for light and transit causes.
Absolutely, and I'm glad you brought it to my attention. As a good political scientist and historian, you pick up on some very important aspects of our history. Absolutely the case. And when I said earlier, Jefferson said that those who analyze and establish criteria for the right to revolution, if there is such, always establish, as with civil disobedience, that one first has to understand that a certain set of conditions are present. Now, we could argue about whether those were present yesterday or today, but the fact is that these groups simply engage in the kind of fantasizing that suggests that it is without grounding in reality, as Jefferson very much was grounded in reality.
Janelle Berg.
Oftentimes the radical right focuses on property rights, and they become very involved in things that they do not want to give up, taxing, for example, but they also focus upon certain things that they do not want to do, such as obtain licenses and so forth. Please comment on the property rights and the relationship that has to the Constitution.
Yes, thank you. That's a subject that's deserving of another article, and I think I'm going to get to it eventually, but I can comment on it briefly. Going back to this claim about the common law as being the dominant and really only legitimate law in the country, that spins into claims about the fact that the state has no authority to pass statutes, for example, that require you to get a driver's license, that require you to pay taxes, and there are related claims that declare the illegitimacy of the income tax amendment and so on. But that's really the source of it, is that attempts to exercise authority in that way are illegitimate because the rights of the citizen were established by the common law. So anything different from that, which is very often anything that we don't like, becomes illegitimate exercise of sovereignty.
Oftentimes, however, when these people are attempting to enforce whatever it is they want to do, they do use the court system that we currently know in order to enforce their rights under what they would call the common law or the constitution as they would interpret it. Isn't that a fact that they've often used our system as it exists?
Yes, that's very interesting. That and there is a certain, I would say, delicious irony in one of the tactics being, for example, to file liens, using what they sort of derived from the authority of the government, but file them with county government in an attempt to take control over people's property. Filing it then with the very government that they claim is illegitimate. I mean, there's a circularity there that needs to be illuminated from time to time. And similarly, to engage in demands for protection of one's civil and social and legal rights, however unusually understood sometimes, in the courthouse, while at the same time denouncing the legitimacy of the exercise of authority. One has to say it's a little hard to have it both ways.
Steve Sheen.
You've done a wonderful job, I think, of describing the characteristics and beliefs of this group. I wonder if you could tell us a little bit about the scope of their membership. I mean, is it a widespread group that, or collection of people who exist across the country?
Well, nobody really knows. I think that there are a variety of claims, but it's hard to pin it down. One of the things that we have recognized is that these groups have engaged in a kind of tactic where they maintain very loose connections with others. There isn't any hierarchy that connects groups together, so it's hard to measure them. They certainly have had, compared to the weight of those, I don't mean weight in body weight, but the numbers, they've occupied a disproportionate amount of our time and lots of people's time because they're so strong in their views and because we've been so puzzled about how to respond to them, which is one of the reasons why we wrote this, to suggest there are ways to deal with this. Mm-hmm. I'd like to say something else, because I dodged the question of numbers because I don't know and I don't think anybody does. But one of the things that we discovered, and I think it's interesting to recognize, is that the ideas that these people propound are not inventions of the 90s. There's a pedigree that extends a long way back into the 30s even, but particularly in the 1950s and 60s we saw lots of similar ideas floating to the surface, and so we've inherited some of that tradition modernly.
We've got very little time, but quickly, and you may have already answered this question, is there any kind of agenda? They're disjointed, you said that, but do you see any agenda floating to the surface, or is it just a collection of radical beliefs?
Well, I think the agenda, and I don't even question sometimes the good faith in which it's exercised, they don't want anybody controlling their lives. I think racism is very much a part of many of the group's organizations. They claim that it is not, but one sees the effects. There is that. There are some rather unusual religious claims that they make, that they would like to see a different form of government that's grounded in what they consider to be biblical principles.
I have to close on that note, Jim. Thank you on behalf of our panel and our staff. That was the most informative program, and we're happy to report to our viewers you'll be back next week to talk about professional ethics and the practice of law. Ladies and gentlemen, I hope you've enjoyed our program as much as we've enjoyed bringing it to you, and we'd like to invite you to be with us again next week at the same time when we will have Jim Vacher back to talk about professional ethics. Until then, please have a good week. I am Tony Stewart.
The North Idaho College Public Forum was videotaped live from the studios of Instructional Technology on the campus of North Idaho College for viewing at this more appropriate time. We invite you to join us again next week for another all-new edition of the North Idaho College Public Forum on this public television station.